The US Supreme Court has won many headlines in recent years, most infamously for overturning Roe v. Wade in 2022. Unlike most other prominent positions in America, the Supreme Court justices are not elected, but nominated by the incumbent president, and yet they have the power to set legal precedences that can last hundreds of years. So in this episode, we're going to find out, what is the Supreme Court? Welcome to America, a history podcast. I'm Liam Heffernan, and every week we answer a different question to understand the people, the places, and the events that make the USA what it is today. Joining me this week is Dr. Emma Long, Associate Professor of American History and Politics and the Head of the Department of American Studies at the University of East Anglia. I swear I'm going to shorten that after a few episodes, but thanks again for joining me and welcome back to the podcast.
Great, thanks to be back.
Yeah,
it's good to be back, I should say.
So, the Supreme Court, it's a big topic.
I think huge.
It really is, and I feel like the Supreme Court has been in the news a lot for things recently. So we're going to just start to dive a bit into who they are, what they do, and sort of lay the groundwork for what I imagine will be many future episodes on things related to the Supreme Court. So first, let's start by talking not about what the Supreme Court is, but who are the Supreme Court, and how does someone get there?
Sure. And yeah, I should point out, I've been studying the Supreme Court for 25 years at this point, which makes me feel old when I admit that. So I could talk about this all day. I just find it endlessly fascinating, and the complexities just make it more so. But okay, so the Supreme Court is currently 9 judges who we call justices, just for clarity in terminology. That number is not fixed by the Constitution. It's been as low as 6 and as high as 10, and various iterations between that, but it's been 9 justices since 1869. So it's considered a number that you don't mess with too much, and those who have suggested it or tried have ultimately failed as far as they've attempted it. So we're talking about 9 people. It's a small group, right, when you think about the power that the court has. It's worth noting that as we're recording this in April 2023, the current Supreme Court is probably the most diverse in its entire history. So there are 4 women on the court out of the 9, so almost half. There have only been 6 women in total, so it gives you a sense of why that's important. There are also 3 people of colour on the court at the moment, and there have only been 4 in total in its entire history. So you begin to get a sense of why it's an important moment when we think about who is on the court and questions of representation. But in other ways, actually, the court's not diverse in other ways. So, for example, of the 9 current justices, 8 of them went to 2 law schools, Harvard and Yale, which is sort of like the American equivalent of Oxford and Cambridge. The only one who didn't was Amy Coney Barrett, who got her law degree from Notre Dame. 8 of the justices were judges before they were appointed to the Supreme Court. Only Elena Kagan wasn't. And while that might seem fairly normal, actually historically that's quite unusual. Not all Supreme Court justices have been judges, although they've all got some kind of legal background. Politicians have been particularly well represented on the court. Chief Justice Earl Warren, for example, was governor of California before he became Chief Justice. Hugo Black had been senator from Alabama. Some have been in government service, so Tom Clark was Attorney General, so the nation's highest lawyer. Elena Kagan had been Solicitor General under Obama. And there was one former president. So William Howard Taft, who was the 27th president of the US, went on to be the 10th Chief Justice of the Supreme Court. The only person to have held both of those roles, we should point out, was quite unusual to do that. So it's diverse in some ways and not in others. And in terms of that legal background, some people have said that actually perhaps the court worked better when it had a mix of people with different backgrounds, because when you're a lawyer and a judge, you are trained to think in particular ways and to think about questions in certain ways, or to formulate it in certain ways. Whereas if you get people who've come from education or politics or business or something along those lines, you might ask different kinds of questions. But that's an ongoing debate.
So that's an interesting point you touch on, and I'm going to get the name wrong here, but the person you name checked that stood out to me was Amy Coney Barrett.
Yep.
Is that correct?
It is, yep.
So if my memory serves me well, she was one of the more recent Supreme Court justices to be nominated, and she was by Donald Trump.
2020.
Yes, and that made some headlines because it was a particularly controversial pick for Supreme Court justice. So I think we need to touch on the fact that because Supreme Court justices are nominated by a president, and presidents often or always have quite a political bias, there are questions, aren't there? There are questions about the politicisation of the Supreme Court, the motives behind why certain people are nominated, and whether or not that has an impact on the decisions that are made.
Yeah. And to say Amy Coney Barrett's nomination was controversial might be underselling it a little bit. Of course, what happened was that Liberal icon Ruth Bader Ginsburg died a couple of months before the election, and Barrett's appointment was sort of rushed through by an administration or by Republicans who had held up attempts by President Obama to make an appointment in 2016, arguing that it should wait until after the election. So you've got either end of the Trump administration, you've got battles over what should happen to the Supreme Court. Yeah, I mean, there's this big debate at the moment about whether the Supreme Court is political or whether it's more political than it used to be in the past. And on one hand, the Supreme Court it's always been political. It can't help but be political. It's one of the three branches of government. It's not just a court, it's part of the government system. It has the power to interpret the Constitution, which there's some debate about whether that was intended in the Constitution as it was written particularly. But since 1803, in a case called Marbury versus Madison, when the court effectively said it's the role of the court to interpret the Constitution when somebody says that one of the other branches has done something which violates the terms of the Constitution, the court has had that power. It's called the power of judicial review, and it's not really seriously been challenged. So now we sort of accept that as given. So it gives it an awful lot of power in the process, and there is concern that judges are making political points. Historically, it partly comes as a result of changing thinking about the way that justices work, right, and about the job of the judge. So in the 19th century, judges were seen as oracles, right? This idea that they looked at the law and they looked at the challenge and they put the two things side by side and went, yes, that fits with that, and so yes, it's legal, or yes, it's constitutional. And it was a kind of mechanical idea. That changed in the early 20th century with what we call realist jurisprudence, which was the recognition that judges interpret the law. They have to, and Supreme Court judges do specifically because they see some of the biggest, most controversial issues. But the idea was that yes, they interpret, of course they do, but they do it within a very specific legal framework. That this isn't them going, well, I want this is how that comes out. More a case of what are the legal principles that govern this and how do we interpret them? And that there's room for disagreement, as there is over any issue, but that it is governed by those legal rules. And that's the view of judges and justices that's governed for nearly the last 100 years. But what's changed in recent years, I guess, is the role of the court has got bigger. for lots of reasons that I suspect we don't have time to go into today, but I could talk about at length. People look to the court more often, it gets involved in more issues, and American politics itself has become more divided in the last 20, 30 years. So these big, important issues carry more weight in terms of how they get decided and how they come out. And that has fed its way into the appointment process. So yes, presidents have always looked to make appointments with people who broadly share their philosophical outlook. We would expect that, I think. But that seems to have become much more prominent in recent years. And because the politics have become more divided, the politics of the appointments have become more divided, and the significance of it has become bigger. So what you then see is the appointment process has become political, and there's a debate about how far a political appointment processes make for political appointments, right? I think we can separate those two things out. Somebody who's at the heart of it, it doesn't necessarily mean that they're political, even if the circus is going on around them. But there's also, of course, the view, and this is much more common in the media and from politicians, both who do and don't like the results that are coming from the Supreme Court, that the justices are acting as politicians, that they're politicians in robes, to quote a famous book title. Now, the justices themselves say that's not how they make decisions. They are absolutely adamant. You can do a very quick search online for this and come up with any number of speeches by sitting Supreme Court justices, both current and former, who say that's not how we do things. It might look like that from the outside, but it's not what we do. We don't sit around the table and go, well, I'm a Republican and therefore I think this, and they don't do that. And it's become quite common to dismiss that, right? To say either they're self-deluding or sometimes that they're lying outright, or just sort of missing the point. I am one of the few people I think you will find who will say I actually agree with them. I don't think they make decisions as politicians. I think they are trained as lawyers. They are trained to look at legal questions, and I think they take that seriously. You don't get to the point that they are in their careers without taking that idea of being a lawyer and being a judge seriously. But, big but coming here, because of the divisions over politics in the United States in, like I said, the last 3 decades or so, some of these legal questions have become politicized, and you see differences in interpretations of legal approaches from people who come from a conservative perspective and people who come from a liberal perspective. So, and you're generally likely to find that if someone's politically liberal, they're going to think about interpreting the law in a liberal way, and if they're politically conservative, they're going to think about the law in a conservative way as well. And that ultimately then shapes the way they think about the issues. So they're thinking about them in legal terms, but those legal terms are shaped by some of the broader political debates that are going on. That's what I think is going on. So I don't think politics isn't completely separate from it, but I also don't buy into the narrative which says that that the Supreme Court is effectively just like another political branch that's no different from Congress or the presidency. And I think it's really dangerous to think about it that way.
So it seems like sort of the gist of what you just said is that yes, the personal value system of the Supreme Court justices can influence the interpretation of cases and the decisions that they then reach, but that's not necessarily wrong.
I just think it's the way it is. Judges are people. Yeah. You can't ask them not to be. We all have the things that we bring to the way that we think about issues for whatever context, and you can be aware of your own biases, but you can't necessarily always turn them off.
Yeah.
So I think it's natural. I think it's inevitable. I think that's always going to happen. I think and I don't think that's ever been any different, particularly on the Supreme Court throughout history. But I think what has happened is that the politics of the issues that they are being asked to decide and the reaction to those issues have become more and more heated. So they look political, even if they're not in the way that we might think of it that way.
Yeah, and I think this is going to be a divisive topic of discussion.
Yeah,
But
like I said, I'm one of the very few people you will find who doesn't buy into the whole they're just politicians. I'm aware I'm in a minority on this, and certainly some of the things that they've done recently make it harder to make that case. But part of, if you like, the way I see my job in trying to understand and explain the Supreme Court is to take what I personally think about the result out of it. Whether I like a result or not is irrelevant in most contexts. My idea is to try and understand how it came about or why it came about. Now, I live in the UK, right? It's easier for me to do that because I'm not living the consequences of it. But I think if you want to study it, you have to try and separate those things off.
yeah, and I think that's a good way of looking at it. But I think if we start to focus a bit more on the actual process of the Supreme Court, because I think the outcomes will be deliberated to the end of time, and no one will ever unanimously agree. But how does a case actually find its way up to the Supreme Court?
Okay, so as we talked about a few weeks ago when we talked about the Constitution, actually, the US is a federal system. There are state laws and federal laws, and there are court systems that grow up in relation to both of those things. So the easiest way I can describe it is basically to think of two triangles side by side, right, with the big base at the bottom. The vast majority of laws are state laws. So if you are hauled up in court because you've broken the law, most of the time it's going to be because you violated state law other than federal law. Federal laws tend to involve things that are really big issues or crimes that cross state lines. So things like kidnapping or terrorism, some really serious murder. So your first level of how you might get to the Supreme Court is the one we're all familiar with, which is a trial. It's a trial court. There's a judge, a jury, or possibly a jury that decides whether you're innocent or guilty of whatever it is you've been charged with. That's the first level, and it exists at both state and federal level. The next step up from that are the appeals courts, and there are both state and federal appeals courts. Now, these courts don't retry the case. Their job is to look at things like procedural errors. So if you think that evidence wasn't considered properly, or somebody did something they shouldn't have done as part of the trial, or something wasn't, the law wasn't applied properly, you can take it to the next level, to the appeals court. If we look at just the state side of things, just for a minute, above the appeals court are state Supreme Courts. Each state has its own Supreme Court, sometimes called that, sometimes called something slightly different. But state Supreme Courts are responsible for interpreting state law. The Supreme Court can't touch a state law. If somebody says, well, this law that you've said I've violated violates the state constitution, that is entirely a state issue, and the US Supreme Court has no jurisdiction. It can't get involved. So in those kinds of questions, the state Supreme Court is the highest of them. Where the US Supreme Court gets involved is in the federal cases, which involve federal law, or if a state law is believed to violate the federal constitution. So, for example, if a state passed a law which said you are not allowed to say anything which criticizes the governor of the state, right? Somebody's likely to come along and say, but that violates the First Amendment, that violates my freedom of speech. That's the federal constitution. So you would probably go up through the state system, but you could argue it to the US Supreme Court because it's about a federal issue. So there are a lot of levels to go through. It usually takes years to get to the US Supreme Court. It's a big undertaking. It's very expensive in many cases to take something that far. And you have to have a fairly serious issue for the Supreme Court to hear it. Roughly, again, the number varies year on year, but roughly 8,000 cases are appealed to the Supreme Court, the US Supreme Court, every year. The number that they hear has varied. When I first started studying the Supreme Court, it was about 100. In more recent years, that number's been somewhere between 60 and 70.
Per year.
So per year. So it's less than 1% of the cases that get appealed to the Supreme Court that the Supreme Court actually hear.
Wow.
And important to note is that since the 1920s, the Supreme Court has had almost exclusive control over the cases that it hears, what's called the Supreme Court docket, which is literally just a posh name for the list of cases it chooses to hear in a particular year. But for various reasons in the 1920s, the court was given pretty much, there are a few exceptions, but pretty much exclusive control over the cases it hears. So when you know that a case is going to the Supreme Court, there are two questions you should always ask, or that are interesting to ask, I guess. One is, why did they take this case? What issue does it raise that is important enough that the court thinks it should take it? And why does it take it now? Because sometimes these issues come to the court before and they've not accepted them, but they accept them at a later point. So those, I think, are always good questions, whether you're looking at the court and its role historically or more contemporary cases, is since it has control, it's chosen to take these for a reason. So what is it?
It's interesting because you said before that the judicial process used to be, and the role of a judge used to be, quite mechanical. And over time, now in the current system, you see how there's a lot of discretion involved in terms of the cases that the Supreme Court hears. There's a certain degree of unavoidable bias in the interpretation of those cases and the ultimate decisions that they come to. And yet the decisions they make and the precedences that are set from that can have such huge ramifications. So my question is, why? When it's just their interpretation, why is their decision so important?
I think it links to the question we were talking about before, actually, and about the court's role in the system of things. So yes, it's interpretation, but there is this idea that it's interpretation within a legal framework, and that those are limits on the justices, which is why I think the current discussion about the justices as politicians potentially is so damaging, both to the court and to the legitimacy of what it does, because it suggests that that's not what's happening. But the Supreme Court, like I said, since Marbury versus Madison in 1803, has sort of accepted this role as being an interpreter of the Constitution within these requirements, and that's largely been accepted. It's been doing it for 200 years. At this point, it's sort of accepted that that's the role that the Supreme Court does. And one of the things that the justices always have to do is provide written opinions. So we don't know what goes on behind the scenes. It's one of the relatively leak-free elements of Washington, which is why the decision in Dobbs versus Jackson Women's Health, which is the ruling that you mentioned earlier, which overturned Roe versus Wade, there was a leak of an early draft opinion a couple of months before it was handed down, and it was so unbelievably stunning because it was so rare for that to happen. Normally the court has been pretty quiet on these things. You don't find out what happens until like 50 years later when you go rummaging through their papers or archives and things like that. So that was really surprising to see that happen. But the part of what the court does is that they provide opinions, which are written explanations for the decisions. They are increasingly open to the public because the Supreme Court has its own website now. So usually within an hour or so of the decisions being announced, anybody can just go to the website and read the opinion and see what the court said. So they have to be reasoned, and there's an expectation that those will be reasoned in legal terms. That it won't just be, well, we like this policy because we were appointed by Republican presidents, and that's why we're going. You're not going to find that. So there has to be a legal reasoning, and that reasoning is important for the court's legitimacy in terms of how it does it. It's also important for setting out how those lower courts that we mentioned before should interpret cases that are similar to it, and how those those principles should be applied in future. So I think the idea that interpretation is part of the process, but it's interpretation within certain limits, I think is also part of why the court is seen to be legitimate. And ultimately as well, because the court, famously Alexander Hamilton said that the court was the least dangerous branch because it doesn't have the power of the purse or the sword. So the Supreme Court doesn't have its own budget that it can pay people to enact the things that it says, and it doesn't have a police force to ensure that it happens. So all it can do is announce its decision and give reasons, and then other branches of government, either the federal government or state governments, need to then put that into practice and enact how that works. And in some ways the legitimacy comes because those other branches, many of whom are elected, accept that what the Supreme Court has said, whether they like it or not, they accept that it's legitimate and put it into effect. So there's a combination of history and constitutional role and the way in which they do their jobs that all play into why the Supreme Court is powerful and why those branches have ultimately followed what the Supreme Court says. But it's also why these attacks on the court and the idea that seeing the justices as politicians rather than as judges is so potentially dangerous to the court's legitimacy, because if people start seeing these decisions as, well, that's by a Republican, or that's by a Republican court or by a Democratic court, or things along those lines, then people might start challenging the legitimacy, and then the whole system falls apart.
America, a History podcast is produced, edited and hosted by me, Liam Heffernan. A special thanks to Dr. Emma Long for joining me on this week's episode. And if you found this episode interesting, you can find out more by checking out the resources in the show notes. And if you like the podcast, do make sure that wherever you're listening, you drop us a rating and a review, because that helps other people find us as well. Next time, I'm joined by Dr. Jacqueline Fear-Siegel and Andy Borden as we take a closer look at the indigenous people of the United States and answer the question, who are Native Americans?